All right. Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Tuesday, February 7th, 2023. We have 9 bills on the docket and over 300 witnesses. And so I'm going to go through the order of bills, and then I also have to make just one other announcement. We have some streaming issues here. So if you want to watch online, you can watch on the YouTube channel, which can be found on the Maryland General Assembly website under the JPR tab, and then you hit the YouTube tab. Is that right? Okay. So, but it's not going to be able to stream from the website. Also, we're going to run through some of the smaller bills first, and then we'll get into the gun safety bills. If you have testified and are not waiting to testify on another bill, if you could go up to the auxiliary room, which is the Amos room, which is on the 4th floor. So if you've done with your testimony, you still want to stay in Annapolis to watch the proceedings, we ask you to do so upstairs in the Amos room so that we have enough room for the folks that are coming in to testify on their bill. So our order for the day, we're going to start off with Senator McKay, Senate Bill 325. We'll then go to 56, 97, 173, 185, 159, Senate Bill 1, Senate Bill 86, and then we'll wrap up with Senator Waldstreicher with Senate Bill 113. So with that, Senator McKay, you're up with Senate Bill 325. And we are now back up on the website as well. So Senator McKay, you get both sides.
Thank you, Mr. Chairman. Members of the Judicial Proceeding Committee, for the record, I'm Senator Mike McKay, representing District 1, representing Allegheny, Garrett, and Washington counties. Thank you for the opportunity to present Senate Bill 325 to you this afternoon. Now, this is a very simple bill. This bill is a local bill and will alter the Washington County Sheriff's salary to be set to 90% of the Washington County State's Attorney's salary. Additionally, this bill will actually repeal the requirements for the Washington County Salary Study Commission to analyze, report on, and subsequently recommend changes for the sheriff's salary. Again, as indicated, this is a local bill, and as such, the bill has unanimous support by the Washington County Commissioners as well as the sheriff. We've included support letters in both, and just thank you for your consideration. Respectfully ask for your favorable report. Senate Bill 325.
Excellent. Thank you very much, Senator. We have Senator Quarterman. Is he coming to testify?
He is not going to. I'm testifying
for both sides. All right.
Yes, please,
great.
Sir.
Seeing no questions from the committee, thank you very much.
Thank you, sir.
Awesome. With that, that'll end the testimony in the hearing for Senate Bill 325. We'll now move on to Senate Bill 56. Senator West.
Thank you, Mr. Chairman. Can I bring up my panel? Thank you. I'm afraid this bill is going to take a little longer than the last one. It's a pleasure to be here to present Senate Bill 56. This bill is somewhat complicated, but I'm going to try to simplify it as much as I can. So in a construction project, there are generally numerous contracting parties. There's an owner, there's the engineering firm, occasionally an architectural firm, the prime contractor, various subcontractors, and other professionals. And when an accident occurs resulting in significant losses, the responsible party and or its insurance company is normally held responsible and must pay for the damages. So let me illustrate this principle with a hypothetical. A professional engineering firm enters into a contract with the Maryland Department of Transportation to do the design work for a new bridge over the Baltimore Beltway. This bridge is now under construction. A concrete mixer is backing into the work area for the bridge construction and runs over one of the construction workers. Under normal circumstances, the construction worker would file lawsuits against all parties that might have been responsible for the accident. Named defendants would include the concrete mixer company, the company which hired the flagman who failed to yell stop, possibly other subcontractors, the prime contractor, and of course the owner. One party who would not normally be sued in this scenario would be the engineering firm which designed the bridge. This is because the bridge design had nothing to do with the accident. This bill is necessary because in certain situations, the owner of the land is so dominant that it can insert into its contract with the engineering firm a provision stating that the design professional would indemnify the owner for all of the damages and expenses associated with a loss on the project, irrespective of the fact that the design professional firm, in this case the engineering firm, was not the proximate cause of the loss. So in the case of the concrete mixer accident, the indemnification provision would force the engineering firm to pay all the damages, even though it had nothing whatsoever to do with the accident. Of course, each design professional firm has its own insurance, but insurance companies decline to write policies with design professionals, providing for the insurance companies to pay for losses that were not proximately caused by the design professional firm. This is because while the insurance company can assess the risk that its insured will cause an accident due to past experience with the design professional firm, the insurance company has no experience with the others on the job site and has no way to quantify the risk that other companies on the site will act in a negligent fashion. Fortunately, contracts containing such clauses are not customary, but some Maryland state procurement contracts and some other contracts used by very large and powerful construction companies insert such clauses into their contracts with engineering firms and architectural firms. These are effectively contracts of adhesion because the design professional firm knows that if it wants the work, it will have to sign an unfair contract. Very large engineering firms and architectural firms may have the resources to take the risk that's associated with these contracts, but for smaller design professional firms, including most minority-owned firms, signing a contract containing such an indemnity provision is in effect a bet the company decision. Because if something should go wrong on the job, even though the design professional played no role in the accident, the damages could be so great as to put the design professional firm into bankruptcy. If the small firm wants the work, it would have to place the very existence of the company at risk by signing a contract containing such an indemnification clause. One obvious byproduct of such indemnification clauses is to deter small companies from bidding on the job. The fewer the bidders, the higher the winning bid will be. Further, these design professional firms willing to bid on such a contract will necessarily try to quantify the extra risk they are taking when signing such a contract and will submit higher bids for the work than otherwise would have been the case if the contract had not contained such an indemnification clause. Current Maryland law provides that in an architectural or engineering contract purporting to indemnify the other party to the contract for damages arising due to the sole negligence of the other party is against the public policy and is void and unenforceable. This bill merely adds language to the existing statute stating that a provision in an architectural or engineering contract requiring the design professional to indemnify the other party to the contract against loss is void and unenforceable unless the fault of the design professional is the proximate cause of the loss. Simply stated, under this bill, the design professional can only be required to indemnify the other party to a contract if the fault of the design professional is the cause of the loss, but not if the design professional was not the cause of the loss. So Senate Bill 56 ensures that small construction contractors aren't footing the bill for accidents they did not cause. I appreciate the committee's consideration of the bill, and we will be happy to answer questions. My panel is here, including Jonathan Shoemaker, who missed the deadline yesterday to sign up, but whom I understand the chair is willing to accept as a witness today. I thank the committee, and after the design panel testifies, why don't we take questions, and I'll be here to answer questions as well. Thank you.
If you could come up to the podium, be best. Thank you.
Sure. Chairman Smith, Vice Chair Waldstreicher, and members of the Senate Judicial Proceedings Committee. My name is Chad Faison. I'm the Executive Director for the American Council of Engineering Companies of Maryland. We represent 90 engineering firms, which employs roughly 7,000 residents of the state of Maryland, with 40% of those firms being SBE, DBE, or WBE designation. So we represent a large swath of firms. You can read our written testimony, so I will not summarize that. I do have one note, though. We are actively working with the Attorney General's office on the bill based on their information. I hope for a favorable report, and I'm going to yield any remaining time to our members and experts. I thank you all very much.
Bet you these folks behind me didn't know they'd be getting into something this hot button today, huh? Here we go. All right. Chairman Smith, Vice Chair Waldstreicher, and members of the Senate Judicial Proceedings Committee. My name is James DeRue, and I'm a Vice President with KCI Technologies, a 100% employee-owned company based in Sparks, Maryland. I'm here testifying today as Vice President for the American Council of Engineering Companies, Maryland chapter, in support of Senate Bill 56. The fundamental purpose of this bill is fairness. In many current state and private contracts, design professionals must contractually commit to defend their clients against oftentimes frivolous third-party claims before there is any determination that the design professional has actually committed an error or has proximately caused the damages. The costs of such defense can be staggering and must be paid entirely by the design firm. This is because professional liability insurance only covers legal costs to the extent that damages are caused by the errors and omissions of the design professional that is insured. This insurance does not provide for legal defense. You can see how this potentially unlimited legal expense could bankrupt a small business that doesn't carry significant cash reserves. In fact, businesses may choose to walk away from opportunities that carry this clause or run the risk of being deemed unresponsive for asking for limitations of this requirement. Senate Bill 56 would preclude the assignment of liability to design professionals for injuries or damages for which they are not the proximate cause. This bill will not inhibit the filing of claims or limit the reasonable liability of those responsible, nor would it reduce the potential awards payable to any claimant. This is not immunity. Design professionals have always been willing to assume liability for their actions, but have serious concerns when contracts require indemnification or a duty to defend against claims for which they are not the proximate cause. We are asking for support, Senate Bill 56. Thank you.
Chairman Smith, Vice Chairman Waldstreicher, thank you for your courtesy today. My name is Jonathan Shoemaker, and I am on the front lines of the issues presented in this bill, as our law firm represents design professionals in both corporate transactional risk management matters, as well as in litigation matters where we interact with the insurance carriers. When a claim is asserted against a design professional, or a claim is asserted implicating their services, the claim will either be meritorious or it will be not meritorious. This bill protects design professionals from exposure to liability in the form of paying for other people's legal fees, as well as for paying for indemnity dollars, until such time as there has been a determination of the design professional's fault, just like every other business in the state of Maryland. Design professionals are not in the insurance business, but when contracts include a duty to defend, which is an obligation to pay for the upfront defense costs, regardless of whether or not there is merit in the underlying claim, the law treats design professionals as an insurance carrier for their client. Unfortunately, unlike other businesses, design professionals do not have the ability to allocate these risks to an insurance carrier. The only way to manage these risks is to pass them along to a subconsultant, who is then forced to absorb the risk themselves. And as the fiscal note observes, there is a material impact to small business associated with the risk that is imposed upon consultants as a result of this. This bill holds design professionals fully responsible for the consequences of their conduct, but protects them from being treated like an insurance carrier. And we would respectfully request that you commend this bill.
Excellent. Thank you very much. All right, so we're going to round out the proponents with our virtual testimony from Ms. Griffin. You're up.
Good afternoon. My name is Anisha Griffin, and I am testifying today as the owner of a certified small disadvantaged minority business enterprise and past chair of the Small Business Committee for ACEC Maryland, to speak on the potentially catastrophic impact that these clauses can have on small firms. Firms like mine quite often serve as subconsultants to larger firms, providing the support and specialized expertise those firms need to deliver projects to their clients. In our role, we are generally not afforded the opportunity to negotiate contract terms, as those are negotiated by our prime contractors and flowed down to us. Those contract terms are generally reasonable, and we have the means to mitigate risks through the insurance that we carry. However, contract terms that require indemnification and defense against claims are not covered by our professional liability insurance unless it is determined that we were negligent, and only to the extent that damages were caused by our negligence. This means that small firms could be responsible for paying significant sums of money that are not covered by our insurance policies for damages that were not caused by factors within our control. And small firms often do not have the financial means to incur those costs without reimbursement and still remain in business. These clauses have the potential to put small firms out of business for something that was not our fault. Senate Bill 56 would provide for reasonable protections for all parties involved. Agencies would still be provided with the means for indemnification, including legal fees, when the design professionals are responsible for the damages. However, design professionals would not be responsible for the negligent acts, errors, or omissions of other parties. I hope that you will vote for Senate Bill 56 to help protect small firms like mine. Thank you for allowing me to speak.
Thank you, Ms. Griffin. All right, that'll conclude the testimony for the proponents of the bill. We'll now, all right, we have a question from Senator Carter, and then we'll switch to the opposition panel. Also, Senator Muse has a question. Senator Carter, you're up.
Thank you so much, Mr. Chair. Senator West, are these provisions rather standard in most of these construction contracts that are done with municipalities?
I'm told the answer is no. They're unusual, but increasingly the state of Maryland includes these provisions in its contracts.
And also some local government, right? Because I'm looking at the city of Baltimore's testimony, and they opposed the legislation, and they list an entire litany of reasons that we can discuss later.
Right.
But basically, they believe that it would have a chilling effect on their ability to attract professionals in these contracts, and also that it would place an undue burden on the city to have to prove a plaintiff's case and then increase litigation, causing the city to have to then go after design professional.
Right.
So
I think it's fair to say this is a ballooning problem. These provisions started to be added to contracts some years ago. And because there's been no pushback until now, other organizations, including the city of Baltimore, said it makes sense. Let's do it. And we can hold the design professionals responsible.
okay, thank you.
Sure.
I want to make sure that its relevancy to small businesses. This appears to me, and as I've listened to Mrs. Griffin's testimony, as one of the reasons that small and minority businesses can't always compete for a job. And I think this is one of the ways. The one that I hear the most is always, why do I have to insure the entire project if I'm only doing 20% of it? This seems to be one of the ways that we can begin looking at, and correct me if I'm wrong, as something that just stands in the way of small and minority businesses being able to compete on a broader level and having as little liability as possible, thus having the funds to continue to compete and grow. And this would have no real impact. And I understand what others are saying in terms of Baltimore, and I know that's not the senator's position, but that's the position of some in Baltimore. I think it will make small businesses, it will cause them to, you will have more actually than less, than fewer, as a result of this provision if this bill passes. Is that the way to see this?
Yes, as I said earlier, for a small company, it's a bet the company decision.
Right.
So if everything goes right, the company makes money on the contract.
Right.
But if something goes wrong, the damages can be so extraordinary that the company can't survive.
Correct.
And so what small business is going to want to bet the company on a particular contract? They'll simply take a pass on it. They won't bid on it because they won't want to sign the contract. They're forced to sign if they win the bid.
Great. Thank you for putting it in, and thank you, Mr. Chairman, for that. But this is a great bill.
Thank you.
Excellent. Thank you, Senator Muse. Seeing no further questions for the proponents, thank you all very much. All right, that concludes the testimony for the proponents. We'll now switch to the opponents. Is Brooke Larimore here? Mike Zoldek? Going once, going twice. All right, that's it. With that, that'll conclude the hearing for Senate Bill 56. We'll now move on to Senate Bill 97 with Senator Carter. Senator Carter, you're up.
My panel is always aggressive. Y'all come up before I call you. Good afternoon, Mr. Chair and members of the committee. This bill will hopefully follow the trend of the first two and not be super long. One, we've been here before, we've heard this bill before, and we've passed this bill out of the Senate before. My panel of witnesses is John Giannetti, Maryland Criminal Defense Attorneys Association, Natasha Kalfani, Office of the Public Defender, Patrice Clark, Maryland Association of Justice, and I believe there is also virtual testimony from an impacted person. And with that, I will begin. Senate Bill 97 will allow an individual convicted of a crime punishable by imprisonment exceeding 1 year to serve on a jury after completion of the sentence imposed, including the term of probation. It will serve two purposes. One, to ensure that all parties, including Black defendants, have a jury of their peers, and two, to re-enfranchise people who have paid their debt to society. Under current Maryland law, an individual convicted of a felony as well as some misdemeanors is precluded from serving on juries. Maryland has one of the most restrictive jury exclusion laws in the country. According to 2019, a report of the Bureau of Justice Statistics, although Black people are only 13% of the US population, they account for 38% of people in jails and prisons. According to a 2019 report of the Justice Policy Institute, Washington, D.C., a nonprofit that aims to reduce incarceration, more of Maryland's prison population is Black than any other state in the nation. The report notes that more than 70% of Maryland's prison population was Black in 2018, compared to 31% of the state population. It's no secret to this committee that Maryland unfortunately boasts the highest percentage of Black people incarcerated in the country. The rate far surpasses the next closest states, Mississippi, South Carolina, Georgia. As a result, very few Black people, especially Black males, have the opportunity to serve on juries in Maryland, thereby denying Maryland citizens a cross-section jury of their peers. Maryland Elections Law 3-102 permits an individual convicted of a felony to vote after completion of a sentence imposed. Senate Bill 97 will grant that same right when it comes to jury service. Senate Bill 97 will be the last step in restoring full citizenship to convicted individuals who have served their debt to society. In so doing, Maryland will be included in the growing number of states, approximately 21, that permit convicted individuals to serve on juries after completions of their sentences. 4 states, Colorado, Illinois, Iowa, and Maine, impose no restrictions whatsoever on the ability of convicted individuals to serve on juries. The main reason, if not the sole reason provided by opponents, is that convicted individuals may harbor biases against the government, and as a result, will always vote to acquit a person charged of a crime. There is no evidence to support this theory in states that permit convicted individuals to vote. Furthermore, this unsupported theory will not be applicable in civil cases. Every individual in society harbors biases, and the courts have a system to weed out those biases during the jury selection process called voir dire. Individuals may harbor a bias to the subject matter of a case and can be identified, that harbor a bias can be identified and removed during this voir dire process. In addition, attorneys are provided peremptory challenges where they can remove a prospective juror for any reason other than prohibition set forth in Title VII, the Civil Rights Act of 1964, as amended. Accordingly, the notion that convicted individuals should be excluded from jury service due to bias against the state is not supported and ignores the jury selection process designed to weed out biases. Moreover, the bias argument used to exclude convicted individuals is grossly inconsistent with the jury selection process in Maryland. As mentioned earlier, every individual has a bias of some type. Individuals have such biases are not automatically excluded under law in other situations. For example, the following examples where this is a strong argument that an individual should be excluded due to potential bias, but are not excluded by law for jury service. These are the examples that we allow under current Maryland law. Police officers can serve on juries in criminal cases. Police officers can serve on juries in cases where a police officer is alleged to have engaged in excessive force. Prosecutors can serve on juries in criminal cases. Crime victims can serve on juries in criminal cases. Medical doctors can serve on juries involving medical malpractice. Victims of medical malpractice can serve on juries involving medical malpractice. Individuals accused of violating someone's civil rights can serve on juries in civil rights cases. Individuals whose civil rights are violated can serve on juries involving civil rights issues. The at-fault party in an automobile accident can serve on juries involving an automobile accident. The party not at fault in an automobile accident can serve on juries involving an automobile accident. These are just a few examples and an argument that we should not discriminate as we continue to discriminate against persons that have been convicted of crimes. Using these examples, we can clearly see that this is an area that we need to improve to catch up with the rest of the country and also to be who we say we are as a state that does not discriminate against persons. The process involving an individual convicted of a crime should be no different than anything else. Voir dire, peremptory challenges ought to be sufficient to weed out bias as they are in all other circumstances. I would urge a favorable report from this committee, as we've done, I believe, twice before, as well as I've said before, the bill has passed the Senate previously. Thank you so much.
Good afternoon. My name is Natasha Calfany. I'm an attorney at the Office of the Public Defender, and I'm asking this committee for a favorable report. We often say that we want our formerly incarcerated people to come out of incarceration and contribute positively to the societies and the communities from which they rejoin. Yet simultaneously, we restrict the responsibilities and the duties that would allow them to do so. Senate Bill 97 would limit the number of individuals who are currently disenfranchised from serving on the jury in Maryland. Where 1/3 of all Americans have criminal records, this bill would allow Marylanders to serve their community through jury service. In particular, this bill would have a significant impact on increasing opportunities for jury representation. Maryland currently, as we heard, leads the nation in incarcerating young Black men, such that Maryland has incarcerated the highest percentage of people who are Black in this country. According to the Justice Policy Institute, over 70% of people in Maryland's prisons are Black men. These are the highest rates, and it bears repeating that these are the highest rates in the country, easily eclipsing the next closest states. This bill changes the current law, which has a more expansive view of the individuals eligible for jury service because of criminal convictions. Individuals with criminal contacts are still members of their community and should not be silenced or prevented from one of our country's most basic civic duties, but also one that individuals with criminal records are directly impacted by and should have the right to participate if after their sentences have been served. For these reasons, we would ask for a favorable report for SB 97.
Hello, members of the committee. John Giannetti. Pleasure to be here. It's good to see some friendly faces, some new faces, some faces that are back. Hey, Senator, Pastor, Senator Washington. I grew up in Berwyn Heights. Prince George's County is in the house. It's good to see. I feel very comfortable in front of this group. I admire what you do, Mr. Chairman, Mr. Vice Chairman. Good to be here. Listen, we've passed this bill a couple times already. This is a common sense bill. and I think it works on a couple different levels. Not only is it right for the justice system, it's better to have a jury of your peers. That's what we're all guaranteed under the Constitution. This allows that pool to be bigger. It allows the individuals who are on trial to have a larger pool of peers. We're disqualifying people. In the Maryland Criminal Defense Attorneys Association, who I represent, we refer to this bill as the jury re-enfranchisement bill. And in other words, people have been disenfranchised from serving on a jury because of their status as a felon. This brings them back. And this bill is, in the way that this bill is written right now, it's interesting, and it's had different iterations over the years. You can look at all the differences. The position that it's in right now is a position that was agreed between the House and the Senate at the end of the year last year. It had actually gone through conference and they had been the same. The House made their bill the same as the Senate bill. So this was poised. There was some concern as to whether or not there was an override enough or the governor was going to sign it. So it's passed this committee several times. Deserve to be able to serve on these juries. At some point as a society, we have to say, it's time to get rid of some of these laws, which frankly were brought in during the Jim Crow era to disenfranchise certain individuals. Hey, you can't vote. Hey, you can't serve on a jury. You can't be a normal citizen no matter what happens. This bill goes at extra length, and not only will it allow people who are felons, but it addresses an important issue. And I have 6 seconds, and I apologize. I'm not going to go one sentence over. It also says, regardless of if you have a charge pending, any felony pending, you're not even found guilty yet, or any misdemeanor that has a charge greater than a year, you're still not eligible. So this addresses some of the issues of who can't serve on a jury. So it does a good job. I hope you support it. Thank you all very much.
Good afternoon, Mr. Chairman, Mr. Vice Chair, members of the committee. My name is Patrice Meredith Clark. I'm here on behalf of the Maryland Association for Justice. The Maryland Association for Justice is the largest specialty bar association in Maryland. We have members who represent civil litigants and criminal litigants across the state. MAJ urges a favorable report on SB 97. I don't want to repeat what has already been said so eloquently by the other members of this panel. But one of the things that Mr. Giannetti just said is that our Constitution, both our federal and state Constitution, guarantees us the right to a jury of our peers. That's both in the
report on SB 97.
Sorry, Mr. Chair. Okay. That's both in the civil context and in the criminal context. And in the civil context and in the criminal context, but I'm a civil lawyer, so I'm going to talk a little bit about the civil context. When you have somebody who is a litigant and they are picking a jury, they're going through the voir dire process, they are entitled to a representative cross-section of society. And as you just heard, right now in Maryland, we do not have a representative cross-section of society. In the United States as a whole, our current legislative framework would make about 6% of people, citizens, ineligible for jury service. Of those people, 30% are Black men. So if you have a civil litigant who is a Black man who goes in and he is presented with a jury pool, it's automatically not a representative cross-section of society, a jury of his peers to pick from. The only Supreme Court of Maryland, Supreme Court now of Maryland, and the Supreme Court of the United States has said that litigants are entitled to a representative cross-section of their society. This bill does that. MAJ urges a favorable report on SB 97. Thank you.
Excellent. Thanks. We have two witnesses that wish to testify in favor of the bill. They're both of whom are virtual. So we'll start with you, Ms. Haven. You're up. Go ahead.
Good afternoon, Mr. Chair, Mr. Vice Chair. My name is Kimberly Haven. And today I'm here on behalf of myself and the tens of thousands of Maryland citizens who are disqualified because of an involvement with the criminal legal system from serving on a jury. Now, as honestly, the testimony that's come before me is exactly what was in my written testimony. But every year I get a jury summons. And every year I have to fill it out. And every year I have to provide reams of documents about my entire criminal history, only to be told thanks, but no thanks. And I get frustrated every single year because, as Senator Carter pointed out, there is no rationale for disqualifying me from serving on a jury. I can vote, I can run for office. I could be among you in the next general election. You don't want me to be, but I could be. If I can be a voice for my community, for my state, the bias that is held against me from serving on a jury, that I am somehow going to be lenient towards a defendant, or I'm going to be anti-prosecution. There is absolutely no research, no evidence, nothing. But research does exist that shows that people like me are actually more thoughtful when we deliberate. The biases that exist are rooted in decades-old fear and stigmatization. It keeps people like me trapped under draconian collateral consequences that we cannot shake. There is absolutely no reason. I am not a second-class citizen, and to deny me the opportunity to do my civic duty, which I and tens of thousands of Marylanders want to do, only keeps me relegated to that status. And I am not a second-class citizen. I urge your support of SB 97. Thank you.
All right, thank you very much, Ms. Haven. Good to see you.
You
We'll
too.
now, likewise, we'll now hear from Mr. Pickney. Is Mr. Pickney in the waiting room? If you could come on in the Zoom room.
Yes. Hello.
Yes, Mr. Pickney, we can hear you. We just can't see you, but go ahead.
How you doing? My name's Walter Pinkney. I was incarcerated for 10 years, first crime. I didn't do it, but I did my time. And there's times I've been selected for jury duty. I'll go downtown to Baltimore City, give them my summons. They'll do a background check. Okay, thank you. Your services are no longer needed, with no explanation. And I'm like, okay, but prior to you summoning me this jury duty, I know you kind of look at certain people's background. So I'm like, I look at it as being disrespected at all times, for the simple fact, every year I get summoned. And I'm to the point now where I ignore it. And then when I do get a summons, a failure to appear, and I explain to them, you already know I have a criminal record, but you still put me on here. It doesn't make sense. And I feel disrespected, because it's like the person before me just said, she can vote, she can run for anything in Baltimore City or in the state of Maryland. But when it comes down to being a part of a jury, they feel that we'll be either unbiased or favor towards the defendant. And I feel that, you're judging me before you even get to know or let me understand what's going on, my side of the story. That's all.
Thank you, Mr. Pickney. I feel the same way. All right, that was not funny. All right. So that'll conclude the testimony for the proponents of the panel. I'll just put one thing in before we switch to the opposition panel, that last year we did pass this bill, but it did not make it off the Senate floor without an amendment. And that amendment included, I want to just make sure that everyone's included. So you could not serve, we still excluded people that you were convicted of perjury, witness intimidation, jury intimidation, or a crime under Title 8 of the criminal law article, which is fraud related offenses. So, I want to put that in there so we have that discussion. Love to have your feedback at an alternate time, not today, but love to get your feedback on that amendment. So I just put that out there. Okay. I know you're always happy to give your feedback, Senator Carter. All right. Thank you all very much. Thank you. All right. We'll now switch to the opponents of the bill, and we'll hear from Mr. Kroll.
Chairman, members of the committee, good afternoon. I'm Stephen Kroll, the state's attorney coordinator for Maryland, executive director of the Maryland States Attorneys Association, and I've been prosecuting cases since 1984. In short, Mr. Chairman, thank you. You brought up basically what I was about to say. There are certain crimes which should exclude people from being considered for jurors. You mentioned perjury, you mentioned the fraud, the forgery. I'd also throw in first-degree murder, first-degree rape, and carjacking alone. So what I suggest is we are all in favor of reintegration. We are in favor of it, but for certain crimes, we can carve out including the ones that the chair just said, they should be meeting the participants who committed those crimes should be excluded from jury duty. So I'm happy to discuss with Senator Carter. I wish she was here. I'd tell her about certain carve outs that are there and they'd be included. But for those reasons, would ask for an unfavorable report as to Senate Bill 97. I'm happy to answer any quick questions today.
Good afternoon.
How are you, Senator Sinder?
I'm all right. Just a quick question. Why do you believe that if people have served their time and paid their due to society, that they should be without this particular right that all other citizens have?
As I mentioned before, I believe in reintegration. That except for those crimes that we just listed that were on the Senate floor last year, and those serious crimes, you forfeit your right to be in a jury when you commit first-degree murder, first-degree rape, and carjacking.
Now, we're
as well
talking
as
about
perjury.
people who have finished their sentences and they've paid
That's
their
correct.
debt back to
That's-
society.
That's been our consistent position.
And you still feel that they should be punished in that manner.
Well, we're not punishing them, but we shouldn't reward them, is my point.
How is it a reward when that's a right to all citizens?
Well, if you commit certain crimes,
But
certain crimes.
you've also paid your debt to society.
I understand.
Okay, thank you.
From the world in which I come from, I do believe at some point everybody's redeemed. I don't know. There's a.
I
seems like-
congratulate
it seems
you,
like
Senator.
and good
I
to see you
congratulate
again.
you. Good
I
to
know
see you.
Very, always good to see you. There seems to be like a thin line between the system as being one that punishes you eternally in this world, or one that is punishment and rehabilitation. And I'm trying to figure out who determines which crimes that one will commit that will say in our society, no matter what you've done to redeem yourself, you're never redeemable when it comes down to these things. I just want to know, and maybe we can talk about it at some
Absolutely.
other time, so I have an understanding. And I know we're saying these major crimes, you should never be, and that's what it's saying to me, reintegrated into society.
I just want to make clear to you, Senator, we believe in reintegration.
Yeah.
I want to make that crystal clear.
I do. Oh, I know you do. But I just want to know at what point do we say there are certain crimes that will never, ever be pardoned by certain people, even if you pay your entire debt to society and you show that that you have changed and that you're moving forward. I just think it's a way of this double punishment and saying you're never being forgiven. But thank you.
And I'm happy to
thank
continue
you.
that in a forum that's got less people in it today.
Yeah, we'll see that.
Thank you, Mr. Chairman. So, we were talking about people who have served their time.
Yes.
I really don't understand why there's an unfavorable for this for this particular bill,
I would just point out, Senator, I know this passed the Senate the last 3 years, so I'm a realist. I'm a complete realist about what's passed and what's not passed. However, the line has to be drawn in the sand that there's certain crimes, the highest order of crimes, there has to be some sort of punishment that society says there's a punishment and we cannot allow you to sit on a jury. You forfeit your right for first-degree murder, for first-degree rape, and for carjacking. There's a line to be drawn in the sand.
Yeah, I just have a hard time either. I'm a real black and white type of guy. A father of 8. So my wife and I know a lot about you're either pregnant or you're not pregnant. So either you're redeemed and you've paid back your time to society or you're not. And I understand that those crimes are concerning, definitely, and heinous. But if they've spent their time, they've done, I just don't understand the difference. It's either being pregnant or not. And so, but thank you, sir.
Sure.
So just one quick question. Is it your understanding under this bill that if someone were convicted of raping a child or child pornography, and they are on a lifetime sex registry, and the bill is drafted, would they be able to serve on a jury?
Without any carve outs, yes.
Okay, thank you.
All right. Seeing no further questions from the committee, thank you very much, Ms. Kroll. Good to see you.
I'm going to the house where there's a lot less people. Obviously.
But more elected officials. So those are the dangerous folks. All right. All right. With that, that'll end the hearing and the testimony for Senate Bill 97. We'll now go to the vice chair for Senate Bill 173. Senator Walsh-Stryker, you're up.
Well, thank you, Mr. Chairman, members of the committee. Recently, this committee has put a great deal of effort into offering Marylanders second chances and expungement opportunities, particularly those who with non-convictions on their records. 2 years ago, the General Assembly passed revolutionary legislation allowing for the automatic expungement of criminal charges and civil offenses that resulted in non-convictions. That bill, which was sponsored by Senator Patterson and our very own Senator Sidnor, passed unanimously and in a bipartisan manner. Senate Bill 173 offers a technical, non-substantive fix to that statute. As you may know, the Maryland Code contained in the books behind us here on the committee is not published by us. It's not published by the state. Rather, these books are published by third-party publishers. As they compile new laws each year, publishers add their own headings to our statutes. Those headings are not substantive law, but they do give people researching the law a hint as to our legislative intent. Judges see them as well when they are ruling on the law. Soon after the underlying legislation was passed, it was brought to my attention that third-party publishers were misinterpreting the law and that the best method to resolve this error is through a technical clarification. That is what Senate Bill 173 does. This bill is a simple rewording of the 2021 legislation to make clear what our intent is so that third-party publishers appropriately categorize the law we already passed. This technical clarification passed last year on a bipartisan, unanimous basis, but got stuck on sine die. I ask respectfully for a favorable report on Senate Bill 173.
Excellent. Thank you, Mr. Vice Chair. We have, Natasha is coming up. Ms. Califani, you're up.
Thank you. Good afternoon again, Chair, Vice Chair, members of the committee. My name is Natasha Calfney. I am from the Office of the Public Defender. I am asking for a favorable report for SB 173. We do believe that this is a necessary clarification, and we believe that this clarification will expand the access of expungements for our clients, which would allow our clients to effectively eliminate the barriers that are often experienced by people with criminal charges, even when there is not a criminal conviction. And so we appreciate Senator Walsh-Stryker for bringing this bill, and we would ask for a favorable report.
Excellent. Thank you very much. All right. We have one virtual. Here you go. Ms. Holmes, you're up. Welcome.
Thank you, Mr. Chair, Vice Chair, members of the committee. My name is Tia Holmes. I am an appellate attorney at the Office of the Public Defender. I just wanted to chime in and reaffirm our support for giving individuals second chances. So we applaud this effort. But more importantly, I wanted to talk from an appellate perspective. As Senator Walsh-Stryker explained, an ambiguous statute causes problems and unintended consequences for the people that the law was passed to benefit. So as an appellate attorney, I often engage in that statutory construction when I argue before the appellate courts. So as we know, the best statutes are clear and unambiguous. And recently, the appellate court has commented on this body's expungement laws, saying that they are complicated. So with that in mind, Senate Bill 173 provides a much needed clarification, and it will make the statutory construction of this law much easier in the future if this issue arises in any particular case. So for those reasons, I believe that this committee should issue a favorable report on Senate Bill 173. Thank you.
Excellent. Thank you, Ms. Holmes. Good to see you. With that, seeing no questions from the committee, that'll end the testimony for the proponents of the bill. We now have Delegate Ray signed up in opposition. Delegate Ray, welcome back to the MGA.
Thank you. Thank you, Mr. Chair. It's so good to see all of my old friends. This is the first time I'm testifying in a while. So I signed up as an unfavorable on this, but it's only because I think there might be some commas missing in here. This bill does not clarify the language, because if me, a common citizen, I've had experience in the General Assembly reading bills, but this one, I had to go over it several times before I really think I understand what it says. So Senator Waldstreicher, if I could ask you a few questions and maybe just help me clarify this. I know it's a hearing. We don't answer questions, but let me put this out there. It's supposed to clarify the language. So are you trying to say that only civil offenses under 5601 of the criminal law article and any crime except must appear violations under the transportation article would be expunged if there's a decision was the acquittal, dismissal, not guilty, no pros? If that's what you're trying to get at, then my question would be, why only civil offenses under the 5601 criminal law article? Are there any other criminal civil offenses that should be expunged as well? Any crime? And that's really where I'm kind of stuck. Is there any crime say somebody is tried and found not guilty, we'd want it expunged. So there's no crime we can think of that would say, no, we should keep that on the books. So I'm just trying to think through this, if that's what the bill is trying to get at, because that's how I read the new legislation. And if that's not what you're trying to get at, then the language still isn't clear. So maybe I could talk with you afterwards and you can just tell me where I'm wrong or reading it wrong or reading it right. And we can put some commas in there or something to maybe clarify the language.
Sure, the Vice Chair will be happy to engage with you afterwards. So
okay,
appreciate it.
So for right now, I'm an unfavorable only because I have those additional questions. So
excellent.
Thank you.
Thank you very much. All right. Seeing no questions from the committee, that will end the hearing for Senate Bill 173. We'll now move on to Senator Beidle. Senator Beidle here. Oh, Senator Beidle, welcome. Senator Beidle with Senate Bill 185.
Thank you, Mr. Chairman, Mr. Vice Chairman, and members of the committee. I wouldn't miss the opportunity to come in front of JPR, my favorite other committee. So thank you. So for the record, I'm Senator Pam Beidle, District 32. Senate Bill 185 is a gun center bill. And those of you that were here last year may remember we passed a bill for the gun center to be expanded to keep records of all guns that are used in illegal guns that are used in the state of Maryland. So Senate Bill 185 just expands and defines. It doesn't change any guns being surrendered or any requirement for surrender. It just simply collects data if a gun is surrendered pursuant to a protective order. So it's strictly a data bill collecting data. I hope I can count on your favorable report. And I know you have a busy day, so thank you, Mr. Chairman.
No, thank you, Senator, and thank you for bringing the bill. You always have excellent bills for gun safety, so thank you.
Could you pass some? That would be really helpful.
Burn, burn, burn. All right. All right. Would you like to bring up your panel?
I can.
Sure, yes, come on up.
Thank you.
Start with you, Ms. Lenig, we'll start off with you.
Good afternoon, Mr. Chairman, Mr. Vice Chairman, if you were here, members of the committee. My name is Dorothy Lenig. I'm the director of the Domestic Violence Legal Clinic at the House of Ruth. Sorry to not be more organized. There's nowhere to sit and take all our coats off. I'm here today to urge a favorable report on Senate Bill 185. First, I want to thank Senator Beidle for bringing this important bill. I think most of you know how important protective orders are to victims of domestic violence. They really use them to enhance their safety. And every final protective order requires the respondent to surrender firearms. That's the state law right now. But domestic violence advocates have been concerned over the years that maybe not all the guns are being surrendered. And I think there have been several high-profile cases where the respondent either didn't surrender the firearms or didn't surrender all of their firearms, and then they shot and killed their victims. The gun surrender process is very local. It's all done by the local law enforcement. So in Montgomery County, they have a very robust system where when the sheriff goes to serve the temporary order, they actually look up what guns are registered to that person, and then they track whether all the guns are surrendered. In Baltimore City, the sheriff also serves, they look up the guns, but the guns are surrendered to the police department. And so they don't know who had a protective order issued against them, so they don't know which guns they're expecting to come back. So again, it doesn't change anything about that you have to surrender firearms. It doesn't change. It doesn't make any guns more that you have to register them. It doesn't change anything about that. It's really just a tracking mechanism because we want to see, are the guns really being surrendered effectively in Maryland? Please note the chiefs and sheriffs put in a letter of support for this bill. Urge a favorable report. Thank you.
Good afternoon, Mr. Chairman. I'm Michael Brady with the Maryland State Police, and I'm here in support of Senate Bill 185. Normally, when you guys put a bill in that says the state police has to collect data, create reports or whatever, we tell you for money, we can do anything. Well, fortunately, last year, when you created the gun center and you expanded its authority, you provided us with quite a bit of money to do that and enhance our systems. At the same time, Mrs. Lennick came to us and said, I want to do this. So we were still in the development phase of that enhancement from last year. So we're able to do this with zero cost. For a change, we won't be asking for anything. And we do have the ability to collect all the data that is requested and create the reports that are requested. So with that, I ask a favorable report.
Great. Good afternoon, Mr. Chair, members of the committee. My name is Michelle Seary. I'm the Executive Director of the Women's Law Center of Maryland. And I'm also here on behalf of the Maryland Legislative Agenda for Women, of which this bill, SB 185, is part of their 2023 agenda. And I am here really to tell you what this bill doesn't do. You've already heard from our wonderful sponsor and from Ms. Lennig about what it does, but what it doesn't do is change anything about our existing laws that state who, when, where, under what circumstances guns must be surrendered. That is already well-established federal and state law. This does not change that. This does not have anything to do with temporary protective orders or interim protective orders. It only has to do with final protective orders. And that's very important because a final protective order comes with full due process. It means that the respondents are personally served by law enforcement and given notice of the hearing. They have the opportunity to testify, to be heard. They can hire an attorney. They can consent or choose to go forward with a hearing. And there must be a judicial finding based on the facts of evidence presented that an act of abuse has actually occurred. That must be found before anything else can happen in a final protective order. So domestic violence cases, we know they're dangerous. We know that firearms make them exponentially more so. And this legislation is just going to help track what information we don't know, because we cannot fix issues unless we have the information there. For all of those reasons, we thank you for your time and ask for a favorable report for SB 185.
Excellent. All right. Seeing no questions from actually Senator Sidnor and then Senator West.
And good afternoon. Ms. Siri,
Yes, sir.
I'm directing this question to you because I know you're an attorney. I was just going through some of the testimony, and someone claims that this type of legislation is unconstitutional. Do you see any problems with constitutionality, just collecting data?
Absolutely not, sir. This is, again, everything else is already established federal law. This is just collecting data.
Thank you.
Thank you.
Thank you, Mr. Chairman. So, Ms. Siri, I'll ask you the question too.
Yes,
Keep
sir.
you on the hot seat.
Ms. Lennig is also a lawyer if anyone has questions.
I cross-examined Mrs. Lennig too many times, so it's your turn. So once all this information has been gathered, what happens to it? The bill doesn't provide any information about how the information is used or who acts upon it.
Well, and I would, if possible, I would like to defer to Ms. Lenning, but I think my first answer would be, we don't know yet because we don't know what we're gonna get. But if I may defer to Ms. Lenning.
Sure, absolutely. Go ahead.
Thank you.
I think the most important thing that I'm hoping for is for all the systems to start to function. So in Baltimore City, I'm hoping this will make the police department and the sheriff's office start talking to each other to figure out what guns are being surrendered. Then I think we can start to figure out, are there real gaps? Let's say you have a county where there are no guns surrendered. I think then we've got to go in and start to look to see what's going on there. So I'm not making any assumptions. Maybe everything's working really well. Maybe it's all working smoothly and we don't have a problem. But I think the domestic violence advocates have long been concerned that things like Baltimore City, where there's no conversation going on, maybe they're not all being surrendered. So hopefully we'll find out there's nothing wrong.
Okay, I guess that makes sense. I like the bill, but I just, at the end of the day, my question is, so what?
Yeah, I think.
Once you get the information, somebody ought to have the responsibility of reviewing it and then making sure that the guns ordered to be surrendered actually are surrendered. And the bill
Yes.
doesn't cover that.
And I think that.
Senator West, I think I can help you with that. The way the gun center works currently is all crime guns are reported by every law enforcement agency to the gun center. So we are able to collect that data on firearms used in crime. This is going to expand it so that when a protective order is made final, that information will go to the gun center. Within the gun center, they can do a workup on every person and find out if they have regulated firearms registered to them. And then the law enforcement agency who they are surrendered to will then have to tell the gun center, this is what we got. So they're going to know if 20 are registered and 5 came in, we're going to let them know. That's not everything they have registered. If 1 is registered and none comes in, we'll be able to let them know. So it is closing the loop of making sure that firearms that are supposed to be surrendered actually do get surrendered.
Okay, thank you very much.
You're welcome, sir.
Lieutenant.
Sir.
I'm just curious and I'm asking, so how does this get handled if someone is in prior to the issuance of the final protective order? If say the person or the subject deems that, hey, this isn't going to go my way, and they decide they're going to go ahead and either gift or sell the regulated firearms.
There is a lawful process for doing that, which they would have to.
Yeah,
go
I understand
through,
that.
Which then, once the 7-day waiting period occurs, the guns get transferred to whomever is a lawful recipient. That goes through our licensing division, which is one of the databases that the gun center checks.
So it cross checks that.
Right. So when we checked,
The reason
I'll use you as the example. You gave away you legally transferred all your guns.
wrong.
When I did the workup on you, if you got the final protective order, it would show you didn't have any left.
So again, so I just want the clarification I'm looking for is that there is a cross check, but that as long as if there is the writing on the wall, the subject is allowed to lawfully transfer those firearms. It could be to a family member not residing in the house, or I don't even know if that even qualifies it, but it could be a family member. Because if once the state police or the local agency were to then take custody of those weapons, they're forfeited. So the
No,
person,
sir.
no?
No. At the end of the final protective order, you still have your ownership rights to those firearms.
So how
after
can you
you're-
take them?
Because you're not able to possess them. You don't have to give them to law enforcement. You can legally transfer them
To another person.
at the end. When the final protective order is issued, you could.
Okay.
If you surrender them to law enforcement because you don't have anybody willing to take them, at the end of the year, you're no longer under a final protective order and you would be subject to receiving your property
Having them
back,
returned.
provided you're not
Provided there's no other
prohibited
issue.
for some other
Okay,
reason.
that's what I wanted to make sure of, that we weren't just taking things away without
No, sir.
a process of transferring them or the
Yes,
like.
sir.
Thank you.
You're welcome.
You have another one? All right, seeing no further questions for this panel, thank you all very much. Thank you,
Yeah.
Senator. All right, is Ms. King Ms. Shapiro. Ms. Pelikanos sitting up there. And Ms. Herron.
Sure. Good afternoon, Mr. Chairman, Mr. Vice Chair, members of the committee. I'm Melanie Shapiro, the Public Policy Director, the Maryland Network Against Domestic Violence for the federally recognized State Domestic Violence Coalition. Here in support of Senate Bill 185, I would like to thank Senator Beidel for her efforts in this bill. I want to explain to you why this is such a significant bill. While it is a data collection bill, the risk of homicide for women increases by 500% with the presence of a gun in a home. The 2021 domestic violence homicide numbers in Maryland were the highest they have been in over 10 years. There were 58 Marylanders who lost their lives as a result of domestic violence in 2021. There were 47 children that were left behind as a result of these deaths. A firearm was used in 76% of those deaths. So for those individuals who are victims of domestic violence who pursue final orders of protection, and the law requires that those firearms be turned in, that is why. Because guns increase the risk of lethality for victims of domestic violence. In January of 2023, there were 882 final protective orders that required firearms be relinquished. And we just don't know without this bill if that in fact has happened. We need to make sure that people are complying with the laws that already exist and that the firearms are being turned in, and this bill will help us accomplish that goal. For all of those reasons, I urge a favorable report on Senate Bill 185.
Good afternoon. I'm Karen Herron, Executive Director of Marylanders to Prevent Gun Violence. I'm here today in support of SB 185. Every year, more than 600 American women are shot to death by intimate partners. Firearms are used to commit more than half of all intimate partner homicides in the United States. This death toll frequently extends to mass shootings, where in more than half of mass shootings, the shooter killed an intimate partner. Nearly 1/3 of mass shooters had a history of domestic violence. We have strong gun removal laws for protective orders in Maryland, but the law doesn't work if it isn't followed. Passing Senate Bill 185 would give us the data we need to see if the gun surrender law is being fully implemented. In the United States broadly, tens of thousands of people who have become legally prohibited from possessing firearms have failed to relinquish them. When a person becomes prohibited from possessing firearms, it's important that stakeholders ensure that they actually follow the law and relinquish any weapons they have in their possession. This is especially critical in the context of domestic violence. In domestic violence restraining orders, where the respondent is often not incarcerated and may be at significant risk of using firearms to threaten, maim, or murder a family member or intimate partner. Far too many states fail to implement standard processes to ensure that people who become legally prohibited actually relinquish them. We need to better understand the efficacy of the current system, requiring the tracking, screening, and vetting of firearms subject to a final protective order to run through a centralized entity will be an invaluable tool, and PGV urges a favorable report.
Hello. Good afternoon, Chair Smith and everyone on the committee. It's been a while since I've had the opportunity to testify here, so it's an honor to be here today. My name is Jen Poliakonis. I'm the Policy and Programming Director at the Johns Hopkins Center for Gun Violence Solutions. Our center supports Senate Bill 185. We view gun violence through the lens of public health, and we conduct rigorous research to ensure impactful life-saving policy. Senate Bill 185 requires local law enforcement to report when firearms are removed or surrendered during final domestic violence protective orders. Now, this small but important step is going to help law enforcement, researchers, and policymakers understand how it's being enforced. Is it working in the way that it's meant to be working? There's strong evidence that laws preventing abusers from accessing firearms can reduce intimate partner homicide by up to 25%. This bill is going to help us understand if that's having that desired life-saving effect here in Maryland.
This data is the foundation of public health, and it's going to enable the evaluation of this law. Senate Bill 185 does not create new gun restrictions, but it does require the reporting of vital data and information. The Hopkins Center for Gun Violence Solutions urges you to support Senate Bill 185.
Good afternoon, Mr. Chair, Senators. My name is Joyce King. I am Chief Counsel at the Frederick County State's Attorney's Office. I am here on behalf of the Maryland State's Attorneys Association on support of SB 185. As my co-panelists have stated, these statistics are truly alarming. Domestic abuse is rooted in a perpetrator's desire to exert power and control over their victim. We know that the most dangerous time for a victim is when they're trying to escape their abuser's control and leave the relationship. It's critical to the safety of DV victims to get the guns out of the hands of their abusers when they've been granted a final protective order by the court. We know that respondents who fail to comply with a final protective order are the most lethal because they refuse to accept a victim's decision to leave that relationship. They refuse to respect the court's authority and ability to protect that victim. What we've seen is that these offenders who lose power over their victims often resort to a homicidal nature. They're in a position to exert their ultimate form of control and deciding whether their former partner lives or dies with the pull of a trigger. MSAA, we met with our subcommittee and we realized that throughout all jurisdictions, the policies were wildly inconsistent and sometimes unknown. This piece of legislation is a great first step to creating oversight, accountability, and collection, which will lead to collaboration and information gathering, which is central to combating domestic violence and gun violence. MSA believes that this bill will lead to a better understanding and development of better policies on how we can protect victims going forward. MSAA asks for a favorable report on SB 185. Thank you.
Excellent. Thank you very much, Ms. King. The committee for questions, seeing none. Thank you all very much. So that will conclude the testimony for the proponents of the bill. We'll now switch to the opposition panel and we'll hear from Mr. Peabody, Mr. Cooper, Mr. Morris, Randall Morris. You can go ahead and get started, sir, while the rest.
Thank you. I'm Chris Peabody from Leonardtown, Maryland, St. Mary's County. Yes, my first question is, what's the purpose of the gun center? And I think I heard the answer was, it's to track guns used in crime. Just what the scenario I've just heard, no crime's been committed yet. A person hasn't been charged with anything yet. So these guns aren't used in a crime. So we're going to misuse the gun center to essentially track. Tracking is a registry. No way around it. Tracking is a registry. All right. I heard the gentleman from the state police say, hey, we already have the money for this. It's not going to cost anything. I've worked for the government for the last 15 years. Nothing doesn't cost anything. And there's always scope creep. It's going to cost money. They're going to come back and ask for more. All right. If a person is deemed a threat and we're going to take their firearms, which I'm not debating, we also need to take their knives, their fists, their hammers, their cars, because all those things can be used to kill someone. So what I heard here from the panel is the fear is that the domestic, the person who's been charged with domestic violence is such a threat that they're only going to use a firearm to kill someone. So if they're that big of a threat, they're going to find something. So let's not stop at the firearms. All right. If you're going to take something from them, take everything they can use to kill somebody. All right. I think our time and our money and our effort we better spent on the front end trying to figure out how to stop domestic violence before it starts. It's a mental health issue, right? All right. So if the person is truly a threat and we're that concerned about it and we want to go track their guns using a system that wasn't made by this body to track guns, all right, we want to track their guns. That person's such a threat, let's incarcerate them until the due process takes. If they're that much of a threat, we can't leave them on the street. Thank you very much.
Thanks, Randy Morris. After hearing him talk with the trooper, yeah, that kind of took care of like a lot of the concern I was concerned about. Just like the taking of the firearm. Other than that, you know, it's who? That was my opposition. But you clarified that with him because I saw your concern with that and. All right, thank you.
All right, thank you, Mr. Morris. Is Mr. Cooper here? All right, with that, that will conclude the hearing, the testimony in the hearing for Senate Bill 185. Thank you very much, Senator Beidel. All right, at this time, you've noticed we've had a little bit of a technical difficulty with the camera catching the witnesses testifying. So we're going to take a 5-minute break while OIS fixes this, and then we will come back. So 5 minutes. Senators, do not leave the chamber, please. It's hard to get you all back here. Yeah, all right. 5 minutes, 5 minutes. All right.